SAC conceded defeat to Ripple. Brad Sherman, the subcommittee chair, said, "If XRP is a security, and you think it is, and I think it is, why are these crypto exchanges not in violation of law, and is it enough that the crypto exchanges have said, well, welcome to the Finance Up channel. If you liked this video, don't forget to like it and subscribe to the channel. Do you think the analysts are right about XRP? Write the answers in the comments. Giving away 500 XRP at the end of the week. One random subscriber will receive XRP coins. Take a look at the instructions in the comments section. All you need to do is write the word XRP, watch the video to the end, to like and subscribe. Having committed tens of thousands of violations in the past, we promise not to do any more in the future. Is that enough to get you off the hook for enforcement?" Quote. Essentially, the chair noted that crypto exchanges in which XRP token was trading during the period in question should all be sued. Sherman asked in the hearing, "The SEC has gone after XRP tokens for trading illegally as security. However, none of the exchanges that earlier listed XRP has been sued." Sherman also mentioned that it appears that the SEC is going after the small fish rather than the big fish. The big fish, exchanges, have completed tens of thousands of XRP transactions, meaning they illegally traded securities. During the hearing, an SEC representative was given a chance to respond to the questions raised by Sherman. Gurbir Grewal, the SEC enforcement director, said he can't respond to what matters we are looking at or not looking at. However, he highlighted that the SEC brought charges against Poloniex for dealing with unregistered securities. Grewal mentioned that the regulator has already strengthened the crypto-focused enforcement teams but said it's inappropriate to make further comments. There is an ongoing case between the SEC and Ripple that began sometime in 2020. The regulator accused Ripple of not registering XRP worth around $1.4 billion as security, but the Ripple network has maintained that its XRP token is merely a utility token used in payments and not simply a speculative asset. A few weeks ago, Ripple's CEO Brad Garlinghouse noted that their case with the SEC had gone exceedingly well. However, he also mentioned that the network would leave the US if they lost the court case. Ripple is not the only crypto network to face a spat against the SEC. Last September, the SEC threatened Coinbase with legal actions for launching any crypto-focused lending services. Coinbase intended to establish a lending program that would allow users to earn interest. However, the SEC declared that this new product would require government registrations. Others like Binance, BitMEX, Poloniex, and Robinhood also found themselves on the wrong side of the SEC. Projects planning to launch crypto-focused spot ETFs are still struggling since the SEC is constantly rejecting every application. The everlasting litigation between the U.S. regulator, SEC, and the San Francisco-based fintech firm, Ripple, continues to see new developments. It seems, for a while, the theme of this lawsuit became granting the amici status, or not. The defendant had filed a letter about the amici request to participate in the expert challenge. Ripple's letter opposed the SEC's motive to throw out amici XRP holders of the case entirely, but the plaintiff remains firm about the said position. In the latest filing, plaintiff, in a heavily redacted letter to Judge Annalisa Torres, requested to revoke the amici status granted to the opposition. Also, to prevent further participation of the XRP holders' representative, John Deaton, in the case. James Phelan, a famed attorney, shared this development in the 20th of July tweet. The SEC, in a heavily redacted letter alleging threats against an expert, asks Judge Torres to revoke amici status granted to XRP holders and to bar John Deaton from any further participation in the case. Here, Deaton stood on behalf of XRP holders and requested permission to write a brief on behalf of the amici, thereby providing the court with the reasons behind more than 67,000 holders purchasing XRP. This move, as per plaintiff, exceeds the bounds of the privileges offered by the amici status. It provides no additional support to Ripple's case as they can make such arguments. The motion seeks to brief factual rather than legal issues, to do so on a non-dispositive motion, and to make arguments that defendants are capable of making. Mavant's motion should be denied, and, pursuant to the court's broad discretion to permit or deny the appearance of amici, Deaton should be barred from making additional filings or otherwise participating in this case. The SEC may seek further relief from the court in light of Deaton's and his followers' recent conduct. Quote, notably, Amici Curiae is an individual or organization that is not a party to a legal case but is permitted to assist a court by offering information. The SEC seems to have shifted to an offensive mode of late, especially after the previous blow. Herein, the respected judge denied the SEC privilege and further stated reasons for the same. That being said, associated enthusiasts didn't see eye to eye with the SEC. For instance, Jeremy Hogan, another closely related attorney, opined, imagine you're a second-year law student who just started clerking at the SEC. Exciting. And then you were given the job of scrolling through Twitter and YouTube to look for anything that makes an attorney and 68K people look bad, so they can be attacked in a pleading. Moreover, some of the investors are of the opinion that barring XRP holders from this case might just make things worse. Attorney James Phelan shared a heavily redacted letter filed by the SEC. He demanded that Judge Torres revoke the amici status granted to XRP holders. The letter also mentioned the restriction of John Deaton's participation in the case. According to the SEC, Deaton tried to enter into a lawsuit, including seeking a court order in another court on his behalf. The commission stressed that in the lawyer's Twitter feed and public statement, Mavants are XRP investors who believe that this case has reduced their profits from the token. It mentioned that back in October 2021, the court rejected Mavant's request for intervention and granted Mavant amici status. This required them to get court permission to file an amicus brief. However, when refusing to intervene, it was concluded that this would delay or damage the consideration of the rights of both parties. The watchdog offered 5 reasons to reject the move. One of them says that Mavants does not hold briefings on legal issues. Instead, they present arguments based on 3,252 affidavits from XRP token holders. Responding to the SEC's statement, John Deaton said the commission had put forward the same nonsensical argument to Judge Ned Byrne. According to their theory, every person selling XRP has violated Section 5. However, exceptions apply only if XRP is a security. He added that any person who has the intention to sell XRP can be considered an issuer. That's why exchanges won't refloat XRP if it's called a security, Deaton added, which is a zero-sum game. The current price of XRP for today you can see yourself on the screens, and the trading volume for 24 hours is $1,294,436,065 US. We are updating our XRP price in US dollars in real time. XRP has dropped 4.08% in the last 24 hours. Do you think XRP will be able to win the court and restore its former price? Write the answers in the comments. That's it for today. Thank you for watching this video to the end. If you liked it, then don't forget to like it and subscribe to the channel.